The High Court has ordered the Director General of Kenyan Urban Roads Authority, Engineer Silas Kinoti, to withhold 173.8 million shillings pending payment to a Chinese firm meant for the construction of the 2 billion shillings 9.8 kilometers municipal road along Ngong Road, Nairobi. Justice Alfred Mabea of Commercial Division ruled that it will be proper to preserve the said monies pending the outcome of an arbitration between the Chinese firm China Xinjiang International Group and Anzan Creations Limited, which it had subcontracted. A dispute has since arisen between China Xinjiang International Group, the main contractor, and Anzan Creations Limited, the subcontracted firm. In 2017, KURA signed the deal worth about $20 million with the China Xinjiang International Group for the dwelling of a stretch of the road from Dagoretti Corner to Current Shopping Center. Xinjiang is one of the Chinese contractors controlling over 50% of KURA projects worth over 25.5 billion shillings that were undertaken in 2021. At the time, KURA said the project is fully funded by the government through the development vote and was expected to be complete within 24 months. The dwelling project will cover 3 sections: Dagoretti Corner, Karen Roundabout, 6.2 kilometers, Karen Road, 1.9 kilometers, and a small section of Langata Road from Karen Shopping Center, 1.7 kilometers. Xinjiang had subcontracted Anzan Creations Limited for provision of various services and construction materials with regard to the construction of 9.8 kilometers municipal road along Ngong Road within Karen area. The dispute arose between the parties after the Chinese road construction and engineering firm failed to pay the local firm 173,801,105.69 shillings. The tender had been awarded by KURA. According to suit papers filed by Anzan Creations in court, the matter was referred to arbitration to determine the dispute, but the Chinese firm was not cooperating with the process of arbitration. The Kenyan firm moved to court to preserve any arbitral award that may be awarded in the dispute between itself and the Chinese firm. It argued that China Xinjiang International Group was a Chinese company and it didn't know any of its assets, the location or its directors, and any contracts they are involved in at the moment. The Chinese firm, however, opposed the suit, claiming that the director of its firm colluded with the local staff, including the directors of Anzan Creations, to embezzle funds from the firm. It argued that the delayed payments by KURA had made it difficult for it to settle its suppliers and subcontractors who currently have judgments against the firm. KURA also opposed the suit, claiming that the local's firm application sought to attach, in disguise of preservation order, an amount that is unverified, uncertified, and uncertained. Justice Mabea, however, noted that it is undisputed that the dispute arising between the parties will be determined through arbitration, and that although the Chinese firm is registered locally, it is Chinese-owned and has no known assets within the jurisdiction. Justice Mabea noted that if the arbitral proceedings proceed and conclude in favor of the local firm, and by that time the Chinese firm has folded business in Kenya, the said proceedings would have been in futility. These projects came in as part of the construction and infrastructure upgrades meant to elevate Nairobi city status and its environs and achieve the Vision 2030 objective of transforming the country to a middle-income economy. China Xinjiang International Group, established in 2008, has been involved in multi-billion construction works in the Philippines, Botswana, and Singapore. The 2 billion shillings Ngong Road project was the first entry in construction in Kenya. Reporting for the Informer, Catherine Chalo.